Good morning to all of you. This video is for the final year students. We are going to discuss the question paper 2020, I believe. Question paper number 2020. I have forgotten the question paper. But anyway, let me check up. Yeah, question number 15. An advocate, I think the Bar Council has made a rule that the advocate who is not practicing within the jurisdiction of the concerned Bar Council, he has to file vakalat by taking the assistance of the local advocate or a member of the Bar Council of that particular court. So, is it correct or not? You have to decide. Yes, definitely. Please remember, this problem relates to the rule-making power of the Bar Council. So please remember, according to section 29, section 30 and as well as 33, so it clearly says that advocates are only the class of persons who can attend before the court. That too, after enrollment, you can practice in any court in India, of course, subject to certain rules and regulations. Normally, after getting your enrollment, you can practice in the Mafsil courts, you can practice in the local courts, number one. You can practice in the High Court of your area, where your Bar Council is located. For example, I am enrolled with Bar Council of Andhra Pradesh, so I can file vakalat or I can practice anywhere in the courts of AP, within the jurisdiction of AP High Court. But if I have to go to Maharashtra, there may be occasions where I have to go to Maharashtra and there I have to take up a case. So if I want to file my vakalat under Order 3, Rule 4, if it is CPC or Memo of Appearance, they do not know who I am. They do not know my credentials. After all, by showing the Bar Council of India ID card, it may not be sufficient because nowadays anybody can prepare any duplicate card. So therefore, the High Court rules stipulate that if you want to file any case in any other court of the Bar Council in which you are not a member, definitely you have to file the vakalat through a known person or through a local advocate. This is the substance. Yes, this is a practice, this is being followed. And there are so many instructions or directions in this regard. I have studied the Odisha High Court regulations on this particular point. So Rule 3 of the Odisha High Court rules say that if any advocate from outside the state, if he wants to file the vakalat, he has to get it done. He has to get it done through the appointment of the local advocate. Local advocate means the advocate who was enrolled with the Bar Council of Odisha. Right? There is a case law also. So this case law is Jamshed Ansari versus the High Court of Allahabad, UP State, 2016. Please remember. So you may be knowing that the High Court has got the power of making rules, rule making power. Under section 34 of the AP Advocates Act, the High Court of Allahabad or any High Court can make rules. So they made rule, same rule number 3. Maybe AP High Court also may be having rule number 3. So anyway, from Srikakalapu Pratima, she has to tell me. Right. Rule number 3. An advocate who is not on the rolls of the advocate of the Bar Council of a state, then he cannot appear unless he is supported by a local advocate. That too, who is ordinarily practicing in such court. So 100% allowable. So please remember that it is not against to the Advocates Act. It cannot be declared as ultra vires because it is for your benefit or for the benefit of the judge also, because judge may not know as to who are you. So this is all to avoid the expansion of the fake advocates. So Of course, Bar Council of India openly said that there are thousands of fake advocates in India, illegally practicing in India. So anyway, in order to get rid of the same, better to get support of the local advocate, right? So please remember, here in this case, the appellant, Mr. Jamshed Ansari, he is an advocate within the rules of Bar Council of Uttar Pradesh. Please remember, Uttar Pradesh Bar Council, yes, he is a member. But when he filed the writ petition in the Allahabad High Court, it is not accepted. Why? Because High Court advocate, his name was not found in the list of the High Court advocates. He might have been registered with the Bar Council of UP, but his name was not found in the advocates list of Honorable High Court of Allahabad. So therefore, they raised objection. So in order to avoid the objection, so he engaged a local advocate, but he did not keep quiet. He challenged the rule. So please remember, Supreme Court held that High Court has got power to regulate the appearance of the advocates in the courts. So this rule is perfectly valid and it is not violative of the Article 19(1)(g) of the Constitution of India. Of course, our friends, they suggested R. Muthukrishnan versus the Registrar General Tamil Nadu High Court bench at Madurai. They stated also, of course, here there the main emphasis on the power of rule making by the High Court, but of course Supreme Court in that case also stated that why do you make rules? Better you ask the Bar Council of India to make the rules, because it is the apex body for controlling the advocates. So I think in my view, R. Muthukrishnan, as suggested by some of the friends, is not that much useful, but this is apparent and clear case law, Jamshed Ansari versus High Court of Allahabad 2016. So actually I have written it, but anyway, yesterday I have discussed with so many of our senior students also, particularly Mr. Pradeep of Inkollu. I think now he is practicing in High Court of Telangana, I think. So he also suggested me this case law. Anyway, this case law is a good one. Right. Question number 16. All of you know, I need not repeat it. This is age restriction. So for 5 years, 20 years of age, and for 3 years, some 30 years of age, like that, age restriction has been passed by the Bar Council. So whether it is valid or not, already umpteen number of times I have told you. The very famous case is Rishabh Duggal versus India 2019. So please remember, education, study, it should be equal to everybody. Law should be equal to everybody. Article 19. So everybody has got a right to study law. So age restriction should not be there. But please remember, the Bar Council of India framed the age regulation rules because old people like me, they are coming and they are coming in the evening hours of their journey and they are spoiling the younger generation. But of course, court said it is not correct. It is a violative of Article 14 of the Constitution of India as well as Article 19(1)(g) also. Therefore, so the Rishabh Duggal case, very clear case, where the Supreme Court held that you can study law at any age, no age bar. And the second case law, Samreen Arif versus the Kolkata University, 2008. You may be knowing this case, already I have made video also. Here, Samreen, he has written the LLB entrance examination. He was allowed to appear for the LLB entrance examination. But at the time of giving seat, his name was withheld because the age disparity is there. He has already completed some 25 years or so. Therefore, he is not allowed. So, court held that, Are Baba, if you have got any objection, you should have raised in the early stage. You should not have asked him to appear for the examination. Having appeared for the examination, having come out successful, now how can you stop his study to LLB? Therefore, allow him for this course. So he was allowed. So these two case laws are sufficient regarding the age restrictions. Now, question number 17. An advocate who lost the case, he alleged imputations against the judge, normally quite common. సో మాకెందుకు చేస్తారులేండి, వాళ్ళకి చేస్తారు, వాళ్ళ కులం వాళ్ళు కదా, వాళ్ళ దేశం వాళ్ళు కదా, వాళ్ళ ఊరోళ్ళు కదా, ఇలాంటి రకరకాల ఇంప్యుటేషన్ చేస్తుంటారు. హియర్ ది ఇంప్యుటేషన్ ఈస్ దట్ ద జడ్జ్ టుక్ బ్రైబ్స్. సో ఈయన ఏమన్నాడు, అఫ్ కోర్స్ we can't assure that which case will win and which party will lose. We don't know. That's why I have been telling you, justice is an elusive aspect. Elusive, we can't define. ఎందుకంటే ఒక కేసులో గెలిచిన వాడు కోర్టులో ఆహా నాకు న్యాయం జరిగిందంటాడు, ఓడిపోయిన వాడు నాకు అన్యాయం జరిగిందంటాడు. సో వాట్ ఈజ్ జస్టిస్? సో దట్ ఇస్ ద ప్రాబ్లం. సో ప్లీజ్ రిమెంబర్, సో ద అడ్వకేట్ హూ లాస్ట్ ద కేస్, so the job of the advocate is to fight for the case and to take it till the logical ending. అంతవరకే మన బాధ్యత, to submit the arguments on behalf of our client. That's all. Don't wait for the result. సో ఇక్కడ భగవద్గీతని గుర్తు చేసుకోవాలి. కర్మణ్యేవాధికారస్యే నా ఫలేన. సో యూ డూ కర్మ, మీరు పని చేయండి, డోంట్ వెయిట్ ఫర్ ద రిజల్ట్. సో డోంట్ బాదర్ అబౌట్ ద రిజల్ట్. Maybe in your favor, maybe in other favor. So you must maintain a dignified attitude. You must be stoic. స్థితప్రజ్ఞుడిగా ఉండాలి. కానీ అందరూ అలా ఉండలేరు కదా. This advocate lost his temper and he said the judge took bribes and therefore he has taken the other side. He has given the judgment to the other party. Please remember, it's not at all correct. You cannot impute allegations to the judge. Yes, definitely you can comment on the judgment. You say that the judgment is not in your favor. The judge did not consider, the judge did not take into consideration. This is a perverted judgment. You can write anything regarding it, but you should not allege anything to the judge personally, definitely. So therefore it is an offense, it is misconduct, and this misconduct can be taken as contempt also. You know, you have to write the definition of the contempt. Contempt is the Courts Act 1961. Yes, definitely. It can be contempt. The court took it as contempt, section 2. Civil contempt, section 2 లోనే definition లో కూడా criminal contempt కూడా ఉంటుంది. You have to mention that it is a contempt because Article 142, Supreme Court is the court of record. They can take it as a contempt also. Council of India, Bar Council of the concerned state, they took it as the misconduct. Both sides, ultimately it was taken as the contempt of court. So he was suspended for a year. Whether it is correct or not, is it violative of Article 19(1)(g)? 100% not at all correct. So please remember the case law. Rajesh Kumar Singh versus High Court of Madhya Pradesh. So it is a DSP's attitude. Anyway, so Rajesh Kumar Singh, he is a DSP. Of course, the case he tried his best to mug up the evidence, to marshal the evidence, produce all the witnesses. Even though they stated well, to his bad luck, the case ended in acquittal. So then he started leveling allegations. I think he came before the press and he stated that he leveled allegations of corruption against the judge. Right? So then, before that, the SI came to the court and he threatened saying, I have seen so many judges like this, and we will see that you are ousted from your post, like that he has commented. It is nothing less than the contempt of the court, taken very severe action against the DSP also. So friends, remember, I told you that Supreme Court Advocates Association versus that state of Gujarat, Nadiyad, that Sharma, inspector, who has handcuffed the judge and paraded him just like an ordinary person, and in that case also it was taken as a contempt. Then another case, Inri Vijay Kurle versus the contemner. So very recent case, it happened I think in the year 2020 or 21. So this Vijay Kurle and 3 others, one of them is former chairman of Bar Council of Maharashtra also. They leveled allegations against Rohington Nariman, verify Vinay Chandra. Yes, definitely. Vinay Chandra, he used abusive language. But here attributing motives against the judge. That's why this is a better case. Vijay Kurle. So they are all members of the Bar Association, but they have leveled allegations against Rohington Nariman. Of course, you may be knowing his father was also a judge of the Supreme Court. and they belong to Bombay Bar. So this Vijay Kul and others, they leveled allegations of corruption against these judges. Of course, not directly, but indirectly. But Rohinton Nariman took it very seriously and issued contempt notices. But even then, even though they have given in writing that apology, the court did not accept. They have taken as a suo motu petition. So the court held that the allegations are scurrilous and scandalous. Pukarlu, scandalous laga. So, and they cannot be permitted that to against the judges. Presently, where is Rohinton Nariman? He is one of the judges of the Supreme Court. So against the judges of the highest court, you cannot level allegations. So definitely he was held guilty of the content of the court. So ఆయన జైలు మీద ఏమన్నారు సార్ again సార్. అండ్ ముత్తుకృష్ణన్ కేసు చాలామంది చెబుతున్నారు కాబట్టి ఇది కూడా నోట్ చేసుకోండి. ఆర్ ముత్తుకృష్ణన్ వర్సెస్ ద రిజిస్ట్రార్ జనరల్ ఆఫ్ హైకోర్ట్ ఆఫ్ మెడ్రాస్. So please remember, here the High Court of Madras, they made rules to debar the advocates who browbeat or level allegations against the judges. సో దాంట్లో చాలా ఉన్నాయి. ఎవరైతే ప్లకార్డ్స్ పట్టుకుంటారో వాళ్ళు రానివ్వరు, ఎవరైతే కేకలేస్తారో స్లోగన్స్ ఇస్తారో వాళ్ళు రానివ్వరు, లాయిటరింగ్ ఇన్ వరండాలో ఉండి అరుస్తారో వాళ్ళు రానివ్వరు, తాగి వస్తే రానివ్వరు, తాగి వచ్చి స్టాఫ్తో తగాద పెట్టుకుంటారు. దీస్ ఆర్ ఆల్ ది రూల్స్ మేడ్ బై ది రిజిస్ట్రార్ జనరల్, దట్ ఈస్ హై కోర్ట్ ఆఫ్ మెడ్రాస్. ఆఫ్ కోర్స్ సుప్రీం కోర్ట్ ఏం చెప్పింది దీంట్లో, మీకు ఎందుకయ్యా ఈ గుంపుకి బార్ కౌన్సిల్ అనే ఒక ఆర్గనైజేషన్ ఉంది, బార్ కౌన్సిల్ ఆఫ్ ఇండియా, వాళ్ళకి వాళ్ళు వింటేనే ఈ అడ్వకేట్స్ మాట వింటారు, మన మాట ఇన్సావడం చెప్పారు. రైట్. క్వశ్చన్ నెంబర్ 18, soliciting work at the gates. So simply to say, straight away case of M.V. Dabolkar. So advocates standing at the entrance of the gate, M.V. Dabolkar case మీకు గుర్తుంటే బార్ కౌన్సిల్ ఆఫ్ మహారాష్ట్ర వర్సెస్ M.V. Dabolkar 1975 అనుకుంటున్నాను. So in this case, what happened? The advocates used to stand at the entrance of the court gate and they used to solicit the powerful or potential clients. ఈజీగా అర్థమవుతుంది, ఎక్స్పీరియన్స్ మీద ఎవడు డబ్బులు ఇచ్చేవాడు ఎవరు లేదు అర్థమవుతుంది. దే యూస్ టు గ్రాప్ ది పొటెన్షియల్ క్లయింట్, దే టు టేక్ దెమ్. నీ కేసు నేను చేస్తానా, నీకు బ్రహ్మాండంగా వస్తా, అదే ఉంది. ఇంజక్షన్ ఆర్డర్ 2 నిమిషాలు వస్తుంది, అవుట్ ఆఫ్ ఆర్డర్ వేస్తాం, స్టే తెస్తాం, రకరకాల కబుర్లు చెప్తారు. అండ్ దే సో మీకు ఏం చెప్పాము, యూ షుడ్ నాట్ యూజ్ టౌన్స్, యూ షుడ్ నాట్ పబ్లిసైజ్, అడ్వర్టైజ్. రూల్ నెంబర్ 36, ఇట్ ఈస్ అగెన్స్ట్ రూల్ నెంబర్ 36. సో అరే గేట్ గార్డ్స్ వచ్చారు, అయిపోయింది. అల్టిమేట్లీ గేట్ గార్డ్ గొడవ పడుతున్నారు. ద మ్యాటర్ కేమ్ టు ది మెయిన్ ఎంట్రన్స్ ఆఫ్ ది కోర్ట్ ఆల్సో. కోర్టు దగ్గరికి వచ్చి ఎవరు పిలిస్తే ఇట్రా పక్కన మాట పిలిచి తీసుకెళ్ళటం. ఇదిగో ఈ కేసు గురించి మాట్లాడాలంటే నువ్వు బార్ అసోసియేషన్ రా, లేకపోతే లైబ్రరీకి రా, పలానా టైంకి రా అని చెప్పి మాట్లాడు. అక్కడికి వచ్చిన తర్వాత పక్కన లాయరుండే ఇది నా కేసు అండి, ఇది నా కేసు అని వాడి ముందు జుట్టు పట్టుకోవడం, అంటే కోర్టు పట్టుకోవడం గందరగోళం అయిపోయి అల్టిమేట్లీ M.V. Dabolkar and 13 others, 12 others మీద సో బార్ కౌన్సిల్ ఆఫ్ మహారాష్ట్ర దే హ్యావ్ టేకెన్ యాక్షన్. సో దాని మీద వీళ్ళు ఏంటంటే మా మీద ఎట్టా యాక్షన్ తీసుకుంటారు, ఇది ప్రొఫెషన్ కదా, మేము మరి మా క్లయింట్స్ని తెచ్చుకోవాలి కదా అని చెప్పి అంటే ఇట్ ఈస్ యూ హ్యావ్ టు మెయింటైన్ ద డిగ్నిటీ, డీసెన్సీ, డెకోరమ్ ఆఫ్ ది ఆనరబుల్ ప్రొఫెషన్, that is legal profession. You should not resort to this. In this connection, please remember the note or words made by Justice late V.R. Krishna Iyer. V.R. Krishna Iyer wrote, the bar is not a private guild. The bar is not a private guild like that of barbers, butchers and candlestick makers. Please remember, by bold contrast, it is a public institution committed to the public justice and pro bono public service. Pro bono means legal aid, free service. Pro bono public service. The license for practice or the enrollment, why it is granted? It is granted for advocates on the following assumption. Em chestarani? Number 1, they will be socially useful to perform to the society. సొసైటీకి ఉపయోగపడేలాగా పనిచేస్తుంటారని చెప్పి దానికోసం. నెంబర్ 2, లాయర్ ఈజ్ ఎ ప్రొఫెషనల్ హూ విల్ పెర్ఫార్మ్ దట్ ప్రొఫెషన్. సో ప్రొఫెషనల్గా ఉంటారు వీళ్ళు, సో ప్రొఫెషనల్ ఎథిక్స్ ఫాలో అవుతారనే ఉద్దేశంతో చెప్పారు. 3, హిజ్ పెర్ఫార్మెన్స్ ఈజ్ రెగ్యులేటెడ్ బై హిమ్సెల్ఫ్, దట్ ఈస్ సెల్ఫ్ రెగ్యులేషన్, నాట్ ఫార్మల్లీ బట్ సిన్సియర్లీ. ఎవరు చూడకపోతే ఒకటి, చూస్తే ఒకటి కాకుండా సిన్సియర్గా హీ హ్యాస్ టు రెగ్యులేట్ హిమ్సెల్ఫ్. The function, ultimately, what is the function of the court? What is the function of the court? The function of the court is administration of the justice. So the advocate should help the court in the administration of justice. So they should not resort to such a type of publicity, such a type of calling the so-called petitioners. So when I worked in Chirala, I had the experience, or I can say bad experience, or వేరే చిరాల పీపుల్ యూ మే ఆల్సో బీ నోయింగ్. నేను మహాత్మా గాంధీ క్లాత్ మార్కెట్కి వెళ్తే నాకు తెలిసిన వాడు చెబుతున్నాను, మిగతా వాడిని చెప్పలేను. అక్కడికి వెళ్తే బయటే కొంతమంది ఉండి మీరు పలానా షాప్కి వెళ్ళండి మీకు మంచి బట్టలు దొరుకుతాయని పబ్లిసైజ్ చేస్తూ ఉంటారు. అలా గేట్ కార్డు నుండి చేస్తుంటారు. మరి లాయర్స్ కూడా అలా చేయొచ్చా చేయకూడదా? చేయకూడదని మేము చెప్తాము, అది మీరు నిర్ణయించుకోండి. బట్ కేసులాగా వచ్చినప్పటికే ప్లీజ్ మెన్షన్ బార్ కౌన్సిల్ ఆఫ్ మహారాష్ట్ర వర్సెస్ ఎంఓ దబోల్కర్ 1975. విత్ దిస్ ఐఎమ్ స్టాపింగ్. టుమారో ఇఫ్ పాసిబుల్ I will discuss 2021 paper. So for this time, thank you very much. I am closing the video. If any doubts are there, please give me a message. మీ యొక్క comments లో పెట్టండి. Already somebody please started comments, it will be useful. Okay, thank you very much. I am stopping.